video conferencing. This is a result of the Supreme Court Justice's order suspending or limiting in-person court proceedings due to the COVID-19 pandemic. Parties have agreed to proceed by way of video conferencing and waive any technical difficulties to this proceeding. The matter before the court is State of Georgia versus Devin Brown. Devin Brown is represented by Attorney Lawrence Lewis, and on behalf of the State of Assistant District Attorney Robbie King. Mr. Brown is charged on warrant number 20W17552 with hijacking a motor vehicle in the second degree. He's charged on warrant number 20W17553 with robbery, and on warrant number 20W17554 with battery. Are those the charges upon which the state is proceeding, Assistant District Attorney King?
Yes, Judge.
You may proceed.
All right, thank you, Judge. We have one witness, that is Officer Edwards. And if you would raise your right hand, please. Do you swear the testimony you shall give in the matters pending before the court will be the truth, the whole truth, and nothing but the truth, so I hope you got it.
Swear.
If you would state your name, please.
Officer Joshua Edwards.
And employed where?
Gwinnett County Police Department.
And are you a post-certified officer?
Yes, sir, I am.
Are you the officer that applied for and received the 3 warrants that the judge just read?
Yes, sir, I am.
Would you please tell the court what happened that led to you seeking those 3 warrants?
Yes, sir. So was December 21st, 2020 at around 3:55 p.m. The victim in this case, Miss Joyce Taylor, contacted the Gwinnett County Police Department to report that her vehicle had just been stolen. She was shopping at the Kroger at 6050 Singleton Road, getting her groceries. After she was done shopping, she was walking out of the store with her groceries, noticed the suspect in this case standing outside by the front doors. And so she walked to her vehicle and kind of noticed he followed her and thought something was, kind of suspicious. Loaded her groceries in the car and sat in the driver's seat and started the car. And that's when Mr. Brown approached her. According to Ms. Taylor's testimony, Mr. Brown pushed her, punched her in the mouth, and then told her to give him everything or he was going to kill her. At that point, Ms. Taylor stepped out of the vehicle, removed her phone and her wallet from her back pockets, gave them to Mr. Brown. He then took them, hopped into the driver's seat of the car, and sped away, fleeing out of the parking lot towards Singleton Road.
Can I interrupt you for a second?
Yes, sir.
You said she had made it into her driver's seat before the defendant approached her?
Yes, sir. She stated that she was seated in the driver's seat and had started the vehicle, and that's when he approached her from the driver's side door, pushed her and punched her in the mouth.
Okay. Did he open the door, or was it still open, or what?
I'm not sure.
Okay. Yeah. Was her window down, or is this something that happened through the window, or was the door opened at some point?
The door was opened at some point.
Okay.
I don't know if he opened it or if the door was still open and she just hadn't shut it yet.
Okay. And she gets out?
Yeah, she gets out, gives him the phone and wallet out of her pockets, and then he jumps in the car and leaves.
Okay. All right, go on from there.
So she contacted us, gave us a rough description of Mr. Brown. We listed the vehicle as stolen, and the vehicle was equipped with LoJack, with a LoJack transmitter. So upon it being listed as stolen, the transmitter began sending a signal immediately. Remember exactly what time. It was around 5:15 p.m., so about an hour and 20 minutes after the incident occurred. I received word that the Georgia Department of Public Safety Motor Carrier Compliance Division, a couple of their officers had LoJack receivers in their vehicle and received a signal from Ms. Taylor's vehicle and began tracking it. They tracked it to the Waffle House at, I believe it's 1100 Old North Cross Road. So they were able to track it there. When they located the vehicle, Mr. Brown was outside of the vehicle, seated on the sidewalk. The vehicle was backed in next to the Waffle House. He was seated on the curb or the sidewalk talking to an employee. They detained him. They told me after they detained him, they found the gold iPhone that Miss Taylor reported as being stolen, as well as the key to the vehicle in his pocket. that point, I then responded to that scene to custody of the vehicle and continue my investigation. Officer Crisby then assisted me in this incident. He went and picked up Miss Taylor from her house, put her in the back seat of the vehicle, and told me he was on the way to the Waffle House. When he got close, I took Mr. Brown out of my vehicle. He was handcuffed. I stood him on the passenger side of my vehicle facing outwards and shined a flashlight on his face so that he was clearly illuminated. Officer Crisby drove past me and Mr. Brown twice with Miss Taylor seated in the back seat, and at that point she positively ID'd him as the suspect that stole her car in this case. I showed her the iPhone that Mr. Brown had in his pocket as well, and she stated that that was her iPhone that was stolen during this incident. Sorry, to backtrack, I failed to mention earlier, Miss Taylor did have a abrasion and bruise kind of to her upper lip on her face from where she stated that Mr. Brown struck her in the face. At that point, I had radio dispatch confirmed that the vehicle was stolen, and it was confirmed. I released the vehicle to Miss Taylor, and she left. I read Mr. Brown his Miranda warning on scene and asked him about the incident. At first, he tried to say that a friend gave him the vehicle. When I asked him who his friend was, I believe he said his name was Daryl, but he couldn't tell me anything else other than his name was Daryl. He couldn't tell me his last name. He couldn't tell me his phone number or anything like that. I then told him that Miss Taylor had already identified him as the suspect in this case, and that I needed him to be honest with me. He ultimately told me that on December 18th, which was the Friday before the incident, he was driving around in a friend's car, as he's homeless and doesn't have a car, and that his friend's car got stolen, and he had been homeless, sleeping on the streets all weekend. He also stated that he was addicted to Percocet and was going through some withdrawals. And he alluded to me that he had become desperate, and he went to that Kroger in order to try to find a vehicle to steal, to have a mode of transportation and something to sleep in. At that point, I asked him directly if he stole that Toyota RAV4, and his response was, and I quote, "I didn't mean to." I then asked him, quote, "So you did take it?" And he then nodded his head up and down, indicating yes. I then asked him about punching and pushing Miss Taylor. He denied that he ever punched her, but he stated that when he approached her, she jumped back and got scared, and upon doing so, hit her face on the door of the vehicle. After speaking with him, I then told him that he was being charged with hijacking a motor vehicle in the second, robbery and battery. He asked me about the robbery charge and what that was for, and I told him that was because he stole Miss Taylor's cell phone and wallet. And he stated that he never took her wallet, but he never denied stealing her cell phone.
Okay. The parking lot where that occurred in, if you didn't say, was that here in Gwinnett County?
Yes, it was. It was at 6050 Singleton Road in Norcross.
Okay, and have you been able to see Mr. Brown on your screen during the course of this hearing thus far?
Yes, sir.
Okay, can you identify something he's wearing for us?
Yes, he's the black male in the jail court video in the green jumpsuit, surgical mask.
Okay, that's all I have at this point, Judge. Thank you.
Okay. Attorney Lewis, your witness. And you have to unmute yourself.
Thank you, Judge. Judge, I only have a few questions. Officer, you observed the injuries on the complainant, is that right?
Yes, sir, I did.
Did you take photos of that?
Of Miss Taylor's injury?
Yes.
Yes, sir, I did.
Okay,
Yes, sir.
was your body cam on when you had contact with her?
Yes, sir, it was.
Okay, was your body cam on when you had contact with my client?
Yes, sir, it was.
Okay, so the conversation that you described between yourself and my client, where he may have nodded when you asked him the question if he took the car, that should be captured in your body cam, is that right?
Yes, sir, it will be captured on mine and Officer Crisby's body cam.
Okay, the complainant in the case, how did she contact you?
She flagged somebody down in the parking lot. It's a very busy Kroger. I don't know if it was a store manager or just a random bystander, but they were able to contact 911 for her.
Was that person still there when you arrived? Do you know?
I'm not sure.
All right. Were there any other witnesses to the incident?
No, sir.
Was there any video from any stores that would have captured the exchange in the parking lot?
Yes, sir. The Kroger has security camera footage. However, where she was parked in the parking lot, again, it was busy, so she had to park kind of far back in the parking lot. And that portion of the parking lot was not captured on surveillance cam.
All right. No further questions. Thank you, Judge.
Okay. Any redirect by the state?
No, thank you, Judge.
Okay. Any argument by defense? Or I'm sorry, any evidence or argument?
Judge, there's no evidence based on the evidence that I've heard. There's no argument, Judge.
All right. So Mr. Devin Brown, sufficient probable cause has been found to bind you over on hijacking in the second robbery and battery. Okay, that concludes this matter.
Judge, one second. I just need to make some things clear. Judge, you had the power. When I first looked at a hijacking motor vehicle, I missed the part where it says second degree.
Yes.
Obviously is not without a weapon. However, because I missed that, I filed the bond motion in Superior Court, and we addressed the bond in front of Judge Byers on Wednesday.
Thank you.
We're not going to address the bond here today, but you do have the power to address the bond. I just want to make sure everybody's on the same page.
Okay.
Thank you, Judge.
Thank you very much. Thank you all.